Good afternoon, everyone. And thank you for joining us today to discuss the new proposed Title IX regulations that were released by the Department of Education last week. I'm Amy Dickerson, and I'm joined today by my colleagues Jennifer Smith, Emily Tulloch, and Caitlin Atlas. Caitlin is our newest member of the firm and member of our Title IX team here at Franczek. We have been anticipating for some time now these proposed regulations, as the department previously announced their anticipated release to be back in April of 2022. And while they were not released as early as initially announced, the department did release them last Thursday on the 50th anniversary of Title IX. So, we want to, as always, remind everyone that these proposed regulations are just that, proposed, and thus they do not currently require schools to make any changes to their practices or policies. The 2020 regulations remain in effect until any final regulations are issued, which could take some time, as we'll discuss. But that said, we do want to spend some time today discussing some of the key changes being proposed in the proposed regulations, including those that we think are particularly significant and what they might mean for your institutions and things to kind of look out for as we go through the public comment period here. For reference, our recent Title IX blog post does include links to both the full unofficial version of the proposed regs, as well as the Department of Education's cheat sheet and summary providing an overview of the major changes. So that may be a helpful reference sheet if you haven't already pulled those up. Also, as a reminder for our webinar today, if you have any questions, you may insert the questions in the Q&A or chat function of the webinar. So with that, we'll go ahead and get started. Before we dive into the substance of some of the proposed changes, let's discuss what it means that these are proposed rules and what schools can expect in terms of when actually changes may be made. So Emily, can you provide some further explanation on what happens now that the department has released these proposed rules that have been anticipated for so long?
Yeah, so you guys may remember the notice and comment period for the Title IX regulations, back in the Trump-DeVos administration in 2018, and we kind of went through that process until, summer of 2020. So this is going to look really similar to that. So once the Department of Education's proposed regulations are published to the Federal Register, the public then has 60 days to submit comments to the Department of Education regarding these proposed rules. The proposed rules have not yet been sent or have been sent to the Office of the Federal Register, but they have not yet been published. So that 60-day period has not quite started yet. As a side note, the Department of Education also stated that it's going to engage in a separate similar rulemaking process for student athletics due to that evolving legal decisions regarding transgender student involvement in sports. So that's not addressed in these proposed rules, but we can expect to see a similar process for those as well. Once that 60-day public comment period has ended, the Department of Ed is going to summarize and respond to the comments that are received and then eventually issue the final regulations. Again, as many of you recall, the Trump-DeVos administration draft rule was released in November 2018, and that final rule wasn't published until May 2020 with an implementation deadline of August 2020, making all of our 2020 summers, just filled with fun Title IX. So the timeline for these rules, is unlikely to be exactly the same as those, but we can anticipate that the final regulations won't be approved for, several months to potentially over a year. So until those new regulations are published and effective, like Amy said, the 2020 regulations are going to remain in place for now.
Thanks, Emily. I know with the school year, upcoming school year, not far off, we've been getting requests to help provide training for new and returning administrators under the current regulations, prior to these proposed regs being released. So Jennifer, do you want to discuss our recommendations and what folks should be thinking about for what the proposed rules mean for their school's current training plans?
Sure. So under Title IX, basically the question is, can you comply with the 2020 regs this year? So, and to answer that question, it would be, do you have people who have already been trained in the different roles and they're going to be serving those roles so you can pull off what you're required to do under the 2020 regs? And so that usually would mean primarily looking at your administrator turnover and who's on first for different things, and just making sure that they have that training. If everyone's already trained, you've been doing this for a few years now, there's not changes, then it could be that there's not a Title IX requirement to do new training now, and it probably wouldn't be the time to just completely reconceptualize the way you're going to handle sexual assault. If you had that kind of project in the works, I would say maybe wait and see where these regs go before we try to clear the deck and redo and retrain everyone. So I would look at compliance, who's new, and can you fill the roles you need to for the upcoming school year? Because we're very unlikely to have new regs, these regs, or whatever the final regs are, actually be implemented this school year.
Thanks, Jen. So, with that, let's go ahead and dive into the substance of the proposed rules and discuss some of the changes that, we each have identified as being particularly significant or of interest to schools. Jennifer, do you want to start us off?
Sure. So gender identity issues are a big one that you've probably seen in headlines about the new regs. If I were to give my 10,000 foot view on how this will change things, I would say that we were both higher ed and K-12 institutions in Illinois, at least, or depending on what state you're located, what the state law. For the most part, we're in a paradigm where we knew that you can't discriminate based on gender identity, but at this point, there's not a lot of structure or procedure requirements around that. So I'm going to say, sometimes I tell people, they ask, well, what is the process for this? Thinking in terms of like an ADA or, Title IX. And it's like, sometimes with gender identity discrimination, we've been able to kind of make up the process, or make, really, there's no template, there's no law. But this is potentially going to move all that under the Title IX umbrella. So it cannot be so, if this is final and gender identity and discrimination and facility access and all that is under Title IX, then it's going to have to be under Title IX. The complaint process will be under Title IX. So but one key thing I would flag, especially for K-12, would be on the parent side. So there's been a lot of discussion, especially in Illinois, about an advocacy from organizations about not including parents unless students consent to that disclosure. That's going to be basically gone by the wayside, because parents have rights under these regulations to exercise all the protective rights, all the complaint rights, all the, it's really, again, more than what we're used to in other K-12, like disability discrimination issues. So that issue could be resolved if these go through. So Amy, I'll throw it back to you, because there's also a big change on the sex-based harassment definition that I know you wanted to touch on.
Yeah, there were a few things that I thought would be worthwhile, to highlight today. So the sexual harassment definition, has been revised to now be referred to as sex-based harassment. And it still includes some of the structural elements of what we saw under the definition under the current regulations, but some significant differences too. So sex-based harassment is defined as still to include quid pro quo harassment, hostile environment, harassment, or one of the big four: sexual assault, domestic violence, dating violence, or stalking. But significantly, the hostile environment definition has now been revised. So under the current regulations, the definition is that it's unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. So that was a big change when the 2020 regulations went into effect, that it was severe, pervasive, and objectively offensive, as opposed to the definition that we had all been previously working under, which was the severe or pervasive conduct, to summarize. And so now the proposed definition for hostile environment sexual harassment would be going back to now have it be, unwelcome sex-based conduct. So a hostile environment harassment would be proposed to be defined as unwelcome sex-based conduct that is sufficiently severe or pervasive, that's based on the totality of circumstances and evaluated subjectively and objectively denies or limits a person's ability to participate in or benefit from the recipient's education program or activity. That definition then also includes expressly particular factors that are to be considered when assessing whether or not a hostile environment has been created. So the proposed definition expressly states that it's a fact-specific inquiry that would include specific considerations, such as the degree to which the conduct affected the complainant's ability to access the education program or activity, the type, frequency, and duration of the conduct, the parties' ages, roles within the school, the location of the conduct, the context in which the conduct occurred, and the control the recipient has over the respondent, and other sex-based harassment in the recipient's education program or activity. So I think it's interesting for a couple of reasons. First, that really broadens the current definition that we're working under for Title IX sexual harassment to really revert back to how OCR used to define a hostile environment, and really makes that definition consistent with how the department views other types of hostile environment claims based on other protected characteristics, as well as more in line with Title VII and some of our state law requirements. The department in their comments discusses how, while under the 2020 regulations, they sought to align that more narrow definition of hostile environment to be in line with the Gebser-Davis court decisions, and the department now in the comments to the proposed regs distinguishes between, notes that the court distinguished between the department's role of enforcing Title IX compliance versus a private right of action for monetary damages that those court cases are really focused on. And so how using a different definition than what was used in Gebser-Davis is permitted and appropriate. I think also the definition, it's interesting that they're really codifying the factors for schools to use when considering that sort of constellation of factors to determine if a hostile environment exists. These have previously been provided by OCR in guidance, but never expressly included in a regulation. It also codifies that it must be evaluated from a subjective and objective standard, or at least it proposes to codify that. Almost seeming like it's really trying to incorporate some of that guidance that we see from the 2001 guidance into these proposed regs. The comments also provide additional examples and explanations for interpreting the various factors, which are worth a read, and certainly something that will be important, I think, to look at if these factors remain in the final regulations, because it does appear that they're taking in those comments at least a pretty expansive view of what could be considered a hostile environment. Again, similar to what we saw previously from OCR. A couple other quick points. I note that the proposed definition for quid pro quo harassment does expressly state that it includes explicit or implicit conduct. That's something that I think was always part of our trainings, but is something that is explicitly now incorporated there. And with those big four definitions of sexual assault, domestic violence, dating violence, stalking, those appears proposed regs are really trying to actually, rather than just referencing VAWA's definitions, are really trying to incorporate exactly what those definitions are to clarify that, as opposed to requiring institutions to look elsewhere. So I think that
Amy, if you remember, I mean, that was kind of messy, the definitions, because it referenced definitions that referenced other definitions, and then there was 2 sets of the possible definitions. So I'm not going to say I'm not glad for the cleanup on that one.
I 100% agree. And I think we're even still working through that because VAWA just recently revised the definition for domestic violence. So that's actually one in which it looks like the proposed regs have expressly said, okay, here's the definition that we are proposing you use for the purposes of Title IX. So I agree. And of course, overall, as Jen, as you were talking about here, you know, the move to refer to, you know, from change from sexual harassment to sex-based harassment, you know, is to clarify that the scope of sex-based harassment includes harassment, you know, based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. So, you know, in terms of takeaways for that, I think, well, currently, you know, we're still, again, operating under that narrower definition because we are still operating under the 2020 regulations. And so it only consider hostile environment sexual harassment to be Title IX sexual harassment if it is severe, pervasive, and objectively offensive. And that any conduct that might not meet those particular requirements would be processed under your other codes of conduct. You know, if these proposed definitions do take effect in the way they are, we would see a shift back, you know, I think to where most alleged hostile environment sexual harassment could fall under your school's Title IX procedures. Now we'll talk, I think in a moment about how those procedures may be significantly modified in ways, but that's certainly going to be, I think, some significant changes. So
I think one thing, Amy, just to, it's not necessarily in the regs, but one structural thing for your institution to think about. A lot separate, you know, Title IX investigations are handled by one group of people and other, you know, complaints are handled by another. This is going to open up that Title IX category significantly. So if you're thinking about organizational structure, of course, we don't know where this is going to land, but it might really change your structure or where you need capacity, because like everything's going to be Title IX again. You know, there's not going to be that big other category where almost nothing is actually Title IX.
It's a great point, Jen. And so to kind of your point earlier, when you're talking about, you know, thinking about your teams and what you kind of is going to be the most efficient and best way for the use of all of your resources for training for this coming year, that may be one thing to think about, that if you have something set up in that way, you know, just being mindful of that and who you're going to have continue to be trained now, and who you might need to bring in the future. So, Caitlin, what particular aspects of the proposed regs jumped out to you?
Yeah, thanks, Amy. One of the things that I found interesting was the change in the live hearing requirement. So this is an important time to note that we have a very diverse audience here in terms of K-12 participants and post-secondary participants. So I'm going to talk about you separately for a moment. Right now, under the current rules, K-12 institutions are permitted to have a live hearing, but a live hearing is not required. Personally, I don't know that I have worked with any K-12 institution that has opted to have a live hearing on a Title IX complaint. Most institutions find, one, that it's extremely burdensome, and two, that it's traumatic for students who are in the K-12 setting. However, the current rules for post-secondary institutions do require a live hearing process. That is one of the biggest changes in the proposed rules that just were published. The proposed rules say that now post-secondary institutions would have the same option to have a live hearing, just like current K-12 institutions, but they would not be required to have a live hearing. So I'm sure I can hear it, even though you're all automatically muted. Some of our post-secondary institutions are breathing a sigh of relief with that proposed change. So remember that right now we still are under the 2020 regs. We still have to have our live hearings for those post-secondary institutions. But if this is something that appeals to you, Emily is going to talk later a little bit about what's next and the public comment process. If that's something that you as an institution think, wow, it would be really nice to not have to have that live hearing, it's something you can submit a public comment So I had, I think, the shortest section of things that we're talking about today. So I am going to turn it back to Jennifer to talk a little bit about employee discipline under the new proposed rules.
So, and I'm not going to say very much other than to say we've always had a conflict. One of the biggest issues I would say with the regs, procedurally, process, legal compliance wise, was you had to have a Title IX decision, or arguably there should be a Title IX decision maker who actually decides remedies. And for both students and employees, that was not possible and continues to not be possible to comply with everything. And I think we're all just holding our breath. It hasn't been a big source of litigation, or I'm not aware and have not been involved in OCR complaints where that's the central issue, but we're monitoring that issue to see if it doesn't get resolved through this rulemaking process. And Emily's going to talk about at least the process has been streamlined. I'm not sure this is completely resolved. We're hoping by the end of it, it is. And I know that those of you who will be making comments, this is one that you definitely want resolved because it was just irreconcilable. So that's one thing we want to flag that we're continuing to monitor.
Yeah, so I know we could probably spend this entire webinar talking about, the grievance process and grievance procedure and what some of the proposed changes for that procedure are. I'm going to go over some of the highlights that we've been talking about in our office that really stuck out to us as, being more significant proposed changes. I know for a lot of you, or for all of you probably, the 2020 final rules really expanded the requirements for institutions to respond to Title IX sexual harassment using a very specific grievance procedure and investigation process that really created a higher burden for schools to meet when responding to those potential violations of Title IX. I think the proposed rules in some ways really lessen that burden with respect to responding to complaints of sex discrimination. So, we talked about earlier, the definition of sex discrimination is broader under these proposed rules. Your institution is not necessarily required, if the proposed rules go into effect as written, they wouldn't be required to adhere to, such a stringent grievance process. So, most significantly, I think the proposed rules allow the Title IX coordinator or one single administrator to serve as the Title IX investigator and as the Title IX decision maker. You'll recall now that these positions are separated, particularly your investigator and your decision maker roles. So if this proposal does remain in the final rules, I think it helps a lot of institutions, and particularly smaller institutions or institutions who are trying to, figure out how to use their resources in the best possible way to kind of, figure out how you're going to train your staff and how you're going to staff your Title IX teams. I also think it potentially provide some continuity during the investigation process if your investigator who has, arguably the most information about the complaint and is the most familiar with the evidence is able to make that final determination. So those are some of the changes that we're seeing in that area in terms of personnel in the investigation process. For the investigation process itself, I think the proposed rules significantly reduce that burden to provide written notifications and reports through the investigation process and decision process. I know a lot of you use our toolkit and a lot of you have gone through this process already, and you'll notice that there's a lot of required notifications under the current rules. And again, those are still going to be in place for now. So you have your notice of allegations, your notice of mandatory dismissals, Title IX interviews with a Title IX party, notices of directly related evidence, the investigative report, notices of hearing and written determinations, appeal. There's a lot of requirements in terms of notifications. So under the proposed rules now, the notifications can be verbal or written, and that includes the notice of allegations. So, theoretically, you could have an entirely, non-documented or almost non-documented, verbal notification and investigation process. We'll get into, analyzing what best practices might be when the final rules are published. But the proposed rules certainly include that option, as well as the investigation report and the written determination are also optional or maybe verbal in the current version of the proposed rules. And then I'll just note too, with respect to exchanging evidence, the proposed rules state, that parties have to have that reasonable opportunity to review and respond to evidence. And that may just be a description of the evidence gathered during the investigation. And it also does away with the requirement that parties be given at least 10 days to review and respond to evidence. So again, lessening that burden, making it a little bit more streamlined seems to be kind of the goal throughout the investigation process in these proposed rules. I know one of the new sections of the regulation, the proposed regulations, talk about parenting and pregnant students as well, and that was something we've talked about that's new. Jennifer, do you want to describe kind of what's changed in that area?
Well, I think just in the interest of time, I would just note, very similar to with transgender students, we're going to bring this population and discrimination complaints, especially and protections, under the Title IX umbrella. So whether it's different than the state law where you are, we'll see what the final is. But again, we're bringing more under Title IX in all the formality you just talked about as far as the complaint process. And so I'll kick it back to you with the jurisdiction issue, which is one that continues to evolve.
Yeah, so I'll just quickly hit on jurisdiction and kind of some of those reporting requirement changes that we've noticed in the proposed rules. The first, with regard to jurisdiction, the proposed regulations include an obligation to address sex-based harassment outside the recipient's education program or activity or outside the United States. So you'll recall that under the current regulations, you're not really required to handle under Title IX conduct that occurs outside the US. So there was a big question when the 2020 rules came out about, what about study abroad? What about, potential international field trips or spring break trips? And we've really taken the interpretation that if it doesn't occur in the United States, it's not going to be covered under Title IX. Now, of course, you can address that conduct under a different policy, but that's still in place for now. But the proposed rule really does remove that requirement, so it would broaden the scope of conduct that would fall under your Title IX policy if adopted. And then I'll just touch quickly on something that stuck out in terms of reporting requirements, in this jurisdictional realm. So under the current rules that are still in place, again, under the current rules, all officials with authority who have actual knowledge of Title IX sexual harassment are required to report that conduct to the Title IX coordinator, right? And at the K through 12 level, that includes all school employees. So that includes individuals that may, otherwise, typically keep communications like that confidential, school psychologists, school social workers. These proposed rules now allow K through 12 institutions to have designated confidential employees who would not be required to notify the Title IX coordinator if a person informs them of conduct that may constitute sex discrimination under Title IX. So again, that really means that under these proposed rules, if they're adopted, not all employees at the K-12 level would be required to report those potential Title IX violations. Those individuals that are confidential would need to be named and identified, and there's certain requirements for who might fall under those categories, but something that we thought was significant that stuck out as we were going through these new proposals.
Thank you, Emily. Well, we're coming up, close to our time today. As Emily had mentioned earlier, there is now this public comment period that will resume once the regulations are officially filed with the Federal Register. So again, until they become final, we'll see what those actually, look like, and it'll be important, of course, then to see what's actually in the final regulations to then make any changes changes that are necessary. But in the meantime, we really appreciate and thank you for joining us today. We will continue to post updates regarding the status of the proposed regulations on our Title IX Insights blog at franczek.com. And we invite you to continue to send any questions or comments our way at title9@franczek.com. And we're happy to follow up in our blog posts as questions come in to, address those through that and with you individually. And you can feel free to reach out to any of us individually as well. But in the meantime, we'll also continue to provide insights and supports on schools' compliance under the current Title IX regulations, as well as we will be providing information soon on upcoming trainings and resources that we will be providing for the 2022-23 school year. So with that, we thank you again and have a great afternoon.